Welcome back to the last part of our conference. Before we proceed to the fourth panel, we understand that some of our guests will be planning to head to another side event, which will start at 4 p.m., which is also very important and hosted by the Hong Kong Bar Association and HKIAC in the Chater House. Don't worry, we will keep our time so that everyone can finish off with our conference, and then we can all proceed to the Hong Kong Bar Association event together. Going back to our conference, with all our guests on stage, for our last panel, we will be looking into arbitral awards. Arbitral award is the final product of an arbitration. Its validity and enforceability is key to the parties. In this panel discussion, we will see how the Hong Kong court and the Singapore court will approach the enforceability exercise. We have here on stage our distinguished speakers, Henry Huang, partner of Grendel Law Firm Shanghai, Mr. Robert Pei, independent arbitrator, Jose Morale SC, and Katrina Lam of DVC. We also have Jacqueline Law of DVC as our moderator.
Thank you, Sabrina. Ladies and gentlemen, I hope you all had a nice coffee break, because I think we're now approaching to issues of the high point of international arbitration, which is recognition and enforcement of awards. Teresa has mentioned during the fireside chat just now that in these unprecedented times, Hong Kong is a super connector. In the context of enforcement, we have seen increasing opportunities and indeed needs for Hong Kong and Singapore practitioners to collaborate with mainland lawyers, either in conducting an international arbitration abroad or to facilitate the enforcement of mainland awards in Hong Kong or Singapore. I've did some homework before today's session. I was trying to find some statistics about the enforcement situation in Hong Kong, and I'm lucky to have found some numbers on the HKIAC's website, but that relates to year 2021. In that year, there were 54 court applications to enforce awards made in all parts of the world in Hong Kong. And there were 13 applications being made to the court to set aside the order granting leave to enforce. And out of those 13 applications, there were 3 successful applications throughout the year. I'm sure there are a lot of experts in the audience today on setting aside and enforcement applications to the Hong Kong court. And you would agree with me that the number of successful applications probably increased over the last 2 to 3 years. But we have also had, over the past half a year, at least 2 cases from our specialist judge to say, hang on to your chairs, ladies and gentlemen. Wasted cost orders might be after you, legal practitioners, if you do not perform your role as the gatekeeper of unmeritorious applications landing to the Hong Kong High Court. And therefore, whilst it ignited some excitement about the enforcement scene in Hong Kong, I'm sure everyone would be interested to know where exactly do we stand today, and therefore it is gives me immense pleasure to have our panelists today who are forefront arbitration practitioners in international arbitrations taking place in Hong Kong, mainland, and Singapore, either as counsel in arbitrations or sitting as arbitrators in those proceedings. Speaking of enforcement of awards, it goes without saying that the way judges read an award when it first lands on his desk will be very different from how parties and their representatives try to read the award when it lands in their email. So I guess the first question I would pose to our speakers today is, how does the court approach and read an award at the enforcement stage? And in light of that content of law, how should the parties and the representatives pursue the setting aside applications or oppose the enforcement applications? And we'll first pass the time to Jose.
Hello, good afternoon. Sorry, the mic is working. Excellent. So just perhaps before I know there's a number of authorities, recent authorities, Hong Kong authorities that we'll be dealing with. So it doesn't just become a reading of cases. Perhaps for those who've come from further away, I mean, for those who are here, apologize for telling you what you already know, but essentially the approach that the Hong Kong courts take to both setting aside leave to enforce is what's generally been referred here and abroad as a pro-arbitration attitude or stance, which means that to the extent possible, you give effect to the parties' bargain, the choice of their bargain, the arbitrators, you respect the award as is written. Different people have different ways of writing awards, and this is sort of reflected in a number of the decisions. We'll see. But ultimately, the three, I think, important factors to bear in mind and why Hong Kong has been so attractive in terms of having arbitrations heard here and determined here is we have the whole ecosystem. So you have the courts, which have been referred to earlier here. So we've got very independent judiciary. We've sometimes compared to other jurisdictions in the region, Singapore, for example, which has the SICC. There's a whole list of eminent judges, including Mr. Justice Reyes, who's formerly a judge of the Court of First Instance in Hong Kong, who sits in the SICC. Perhaps what is not so often said is actually that in Singapore, one of the reasons why there's this SICC list, of course, is because you have to be a citizen to be a member of the judiciary of Singapore, which is not uncommon in other jurisdictions. Now, Hong Kong, because of historical reason, and as is reflected in the basic law, there's no such requirement. So there's no citizenship or right of abode requirement except for two senior positions in the Hong Kong judiciary, and that allows it, of course, to tap into a wider range of talent that would otherwise be available. And in particular, if you want to talk about arbitration, so there are a lot of the judgments that you hear about, either Mr. Justice Reyes, who's now come back as a Deputy High Court Judge, or Madam Justice Mimi Chan, who previously was a partner of Alan Novery. So that's one element. The other, of course, is access to the pool of lawyers. So both in terms of doing the arbitration itself, so as you all know, there's no requirement that counsel or the advocates doing the arbitrations have to be locally admitted. Now, once you get to court, of course, normally, as you would expect in any jurisdiction, only those who have the rights of audience and are qualified to practice in those courts can appear in court. And of course, we have exceptions. So every year, the Hong Kong courts admit a number of on an ad hoc basis. Lawyers, usually barristers, more often than not from England, but I think we've also had from Australia, to do cases on the basis that they have expertise which is not locally available, or that they would add a dimension such that the local courts would find itself to be assisted. Now, for arbitration, there's an additional factor, which is sometimes referred to as the arbitration factor, such that if you have a fairly complex case, which was done partly at least by counsel who was from overseas, if there's a court application on a proper case, not any case, the test is adjusted for what is called the arbitration factor, because the courts recognize it's both to the benefit of the parties and also of benefit to the court. The counsel who has done the arbitration and is familiar can be admitted. So whilst, of course, it's not automatic and on any case, but for a case which is sufficiently substantial, admission of that counsel together with a team of local counsel is something which one often sees. So in fact, in two of the judgments which will be referred to today, there was both local silk, local junior, but also the overseas counsel who was involved in a pretty heavy arbitration. So that, again, I think is a factor which is quite special, and we would think tilts the balance in favor of Hong Kong compared with other arbitration centers not far away. So with that sort of general point out of the way, basically reflecting what I've just said, basically in terms of the court's approach in setting aside awards and also opposing enforcement action. So that there are two tensions. The first, of course, is the court trying to, insofar as is possible, enforce proper awards in Hong Kong. So the vast majority, I can't remember what the statistics were a moment ago, but it's way more than 95% of awards are regularly enforced. So the idea is you enforce awards and you do so as quickly as possible. And so there are ways which the courts have devised around that. So if you want to resist leave to enforce, you want to resist setting aside on occasion some form of security is ordered so that you have to pay in order to play. Now, that's the sort of thing which is done in terms of the courts, the jurisdiction of the tribunal. So we all know this competence issues. Of course, primarily it's for the tribunal to determine its own jurisdiction, but pursuant to Article 16, I think, of Yingzi Trial Model Law, reflected in Section 34 of our ordinance, the tribunal's jurisdiction is not binding, so a party dissatisfied within 30 days can have access to the courts to challenge that. But obviously the courts will have regard to the reasoning of the tribunal. And I think one of the examples recently is the decision of Deputy High Court Judge Reyes, as he now is, in AAA, which has been referred to many times today, when the case of related contracts, in that case between a loan agreement and a promissory note, the question was whether or not one should, as one of the parties argued, allow one of the parties to say, although there are two clauses, really it all arises out of the same thing, it makes more sense to have one tribunal deal with everything. The court basically said, although it would be desirable, if clearly this is not what the parties as a matter of contract have agreed, then you can't basically force it upon them, as sensible as it may be. So ultimately, it's recognizing the party autonomy and the contractual bargain that the parties have themselves formed. So that's one example. And basically what the court said is it recognizes that when you've got multi-contract situation, which is common nowadays, insofar as you can, of course, one would hope that you could have everything determined at the same place at the same time. But if that's not what the parties have agreed, then the courts can't force the parties, and neither can the tribunal. So I think these are just illustrations of the wider principles that I've referred to a moment ago.
Thank you. Katrina, any further observations on the Hong Kong court's approach?
Well, I think I'm going to follow that up with two cases. I think that really illustrates the Hong Kong court's pro-arbitration and pro-enforcement approach. And these two cases were handed down earlier this year. And they're both quite extraordinary cases. The first is a case called SHE and YLC, where the Madam Justice Mimi Chan did not hesitate a moment for dismissing an application just because somebody had filed an originating summons without filing a supporting affidavit at the same time. Now, this might seem very harsh because the originating summons was filed in time, but the affidavit, I think, was filed maybe 2 months later. And I don't think anyone will doubt that it is bad practice or a procedural defect, but what takes it from bad practice to an abusive process, which is the basis on which the court dismissed the application outright. Now, the court, of course, explained that under an arbitration agreement, the parties had submitted their disputes to arbitration, and of course, they had also agreed that the arbitral award be final and binding on the parties. So once an award is made, the parties are expected the award to be final and binding. Therefore, if recourse is to be made to the court, then it should be made properly so that the parties know where they stand in terms of the award. So this is a very good reminder that, I think as Jose mentioned, there's the arbitration factor involved, is that in arbitration proceedings, there is a unique procedural regime where parties are expected to adhere to stringently, and is applied almost mechanically. The second case, it's called as CNG&G, where Madam Justice Mimi Chan devoted, I think, 2 pages in the first 3 paragraphs of her judgment to express her dissatisfaction with the manner in which one of the parties had tried to challenge the award. And it is quite an entertaining read, and I recommend all of you to, all of you arbitration nerds to have a go at it if you can't find anything better to watch on Netflix. And she began by saying this, and I'm quoting, "This is a typical example of a party which has agreed to submit its contractual disputes to the final and binding determination of an arbitral tribunal, but being aggrieved when the tribunal makes an award against it, makes all attempts to find loopholes and problems in the award." She then reminded the parties that, of course, arbitration is a consensual process to which the parties have voluntarily agreed to, with whatever inherent defects and risks there may be. So the limited recourse under the arbitration ordinance is not an opportunity for parties to ask the court to revisit the award with a fine-tooth comb or to look for defects and imperfections. And then she issued a very strong warning to all the legal professionals, and she said, and I quote again, that legal professionals should carry out their duties to the court and to act responsibly, hinting the other party didn't act quite responsibly, I guess, when advising their clients on whether an award can be properly challenged, bearing in mind that public resources are involved when judicial time is taken up by lengthy but at the root, unmeritorious application. So reading between the lines, I think what the court is essentially saying is that in order to do its part in maintaining Hong Kong's status as the most desirable arbitration hub, its time and resources must be reserved only for meritorious cases.
Robert, I know that you are also very experienced in the Singapore arbitration circle. From your observations, does the Singapore court show similar or dissimilar sentiments to what Jose and Katrina has described to us?
Well, thank you, Jacqueline, and thank you to Devo for inviting me to speak. And yeah, I'm going to talk a little bit about Singapore cases, having spent 20 years based in Hong Kong. But I do quite a bit of work in Singapore. And in preparation for this, I conferred very closely with the former CEO and registrar of the Singapore International Arbitration Centre, who's sitting right there with the red tie on. This is Mr. Min Nang-u. So if I say anything wrong, he's going to put his hand up and stop me. But I think the short answer is yes, of course, the Singapore court adopts a very similar approach to the Hong Kong court. Applications for setting aside are very difficult for them to succeed. And I will come on, there's an exceptional case that I'll talk about a bit more in answer to one of the other questions, where the Court of Appeal in Singapore did set aside an award and did name the arbitrators involved. And I've just felt so sorry for them. I mean, that is the ultimate nightmare. And the court was very scathing. So I'm obviously not going to name the arbitrators, but I will come on to that case. But just in summarizing the general principles... The Singapore court must adopt a pragmatic approach when resolving challenges to arbitral tribunals and their awards. It's not common in Singapore for awards to be set aside, and the courts have done so in exceptional cases when the grounds are clearly made out. So that's a quotation from a case called CAJ against CAI. And then it's well established that the Singapore courts firmly maintain a policy of minimal curial invention in I think that can't be the right quote. It must be intervention in arbitral disputes. Fine line. Yeah. Subject to a narrow and exhaustive list of exceptions. So the general principles adopted in Singapore are very similar to those in Hong Kong. I'll hold fire on the Court of Appeal case I mentioned earlier, and I will bring that up in response to some of the other questions Jacqueline has prepared. Thank you.
Thank you. And I'm sure the audience would be interested to know, in light of all the increasing number of enforcement applications of mainland arbitral awards, what does mainland parties and mainland practitioners feel after having read increasing number of judgments from the common law world about the recourse that they can have or cannot have in light of what happens in an international arbitration?
I think that's the justification of not to be heard. Actually, very good question, and actually very good panel as well. I was hesitating whether I should sit in this panel or elsewhere, because there are so many examples of bad experience in being set aside by mainland Chinese arbitral awards, I would say. Before we go into details, I think perhaps some background information would be helpful. In China, in mainland China, we're talking about a jurisdiction with over 280 arbitral institutions, with almost 500,000 cases being handled every year. So if you look at the number, you know that it's not surprising. Well, sometimes it's surprising, but it's not that surprising that for some cases, they are actually, I mean, for some arbitral awards, they are set aside by different jurisdictions, and even in China, in mainland China as well. Having said this, I would say that from a practitioner point of view, it's the China tradition, it's the mainland China tradition that every time the losing party would try every chance to set aside the award if they unfortunately were the losing party. You don't look at the voluntary performance of that award. It's always enforcement. And it's always the way try to bring this in front of the court and try to set aside the award in a judicial review process. So that's one side. On the other side, I think many mainland Chinese practitioners like myself are also arbitrators with different institutions. And when that famous case came out, enforcing or ensuring the right to be heard, I told my co-arbitrators every time when there's an online oral hearing process that ensure to be in front of the camera every minute. Ensure that when one face is off, the presiding arbitrator need to stop. I experienced all of them. I experienced my co-arbitrators fall asleep in the hearing. Well, that happened well, usually because one of the counsel started to do his presentation, which is long, which exactly is following what is there in the written statement already. But you can't let that happen, right? So you have to stop him. And there are situations where the arbitrators start to negotiate with the counsels that we need to stop this. We need to end this hearing at 5 because I need to go into my next appointment after 5 p.m. And things like these happen in mainland China's arbitral hearings. And things like these need to be avoided, I would say. After I have so many, I've said so many negative parts of the mainland Chinese practice. Perhaps I will save some time to speak about the interesting observation of how things are, being handled elsewhere. In mainland China, a typical arbitral hearing will take like 3-4 hours. Half a day maximum. There are situations where the tribunal is familiar with the common law style way of hearing. Therefore, there's even POs coming up and set the hearing time to be 1 full day or even 2 days. You need to be very careful in doing that because you will see that counsels may neglect that sometimes. Not by not attending the hearing, but by repeating their statement, their defense, their opinions all the time, without a very productive way of moving forward the arbitral proceedings. To sum up, I would say that mainland Chinese practitioners sometimes find it very, very interesting in comparing different jurisdictions in their attitudes on habitual practice, as well as on the court's views on different judgments or awards.
Thank you, Henry. I think all the panelists sharing, it actually ties in very well with the keynote speeches that we have heard this morning about increasing use of virtual hearings in arbitrations. And I remember Mr. Justice Teng mentioned it's the tribunal really aims to achieve concentration without elimination. Very powerful phrase. And there were panelists mentioning list of issues being used either for expert sessions or the entire proceedings. So in light of the time, I'm going to throw in some sub-questions, which all ties in well with the notion of right to a fair hearing. I think from Henry's sharing, we know that from the different litigation norms and traditions from different parts of the world, sometimes it might give rise to different ideas of public policy depending on different jurisdictions. And we'll invite our panelists to express some thoughts on, is there any common standards of public policy pronounced by the courts, either in Hong Kong or Singapore, on what is meant by public policy being a ground to refuse enforcement, and also when can a tribunal be really treated as having failed to deal with the issues or to give adequate answers? We'll start with Robert this time.
Sure, okay, thank you. And I will just quickly build on Henry's point about arbitrators falling asleep. One of the great cases when I was an associate was before Professor Elie Lauterpacht, the late Professor Elie Lauterpacht. And on the first day of the hearing, he said to us, it's my practice after lunch to have a nap, so it will be a very long lunch break. And we were starting to think, oh no, you know, perhaps he's past it. But of course, no, he had his nap and he was razor sharp throughout. So yes, sleeping at the right time is critical. But yeah, coming back to right to a fair hearing and the case I did allude to earlier, and I think in all fairness, I will give you the citation for anyone who has a prurient interest in such matters. So it's BZW against BZV, 2022, SGCA1. And the key learning from that case that I took away is you have, well, lists of issues really matter, and that's a way of tying the parties down. Because the real problem that the tribunal encountered there in that case was they came up with reasoning for their decision that had not been put forward by either of the parties. And they also came up with legal reasoning that was not based on any of the authorities that the parties had relied on. Now, of course, I mean, looking at it after the event, these seem somewhat like schoolboy errors, but it was a very experienced tribunal, and I'm sure at the time they didn't realize that they were departing so far from what the parties had been arguing. And so, yeah, I mean, it's only in exceptional cases in Singapore that setting aside will be ordered, but it can happen. Maybe I'll just quote a little bit from the judgment. The court said, the court accords the tribunal fair latitude to determine what is and is not an essential issue. That a tribunal's decision is inexplicable is but one factor that goes towards establishing that the tribunal failed to apply its mind to the essential issues arising from the parties' arguments. So, I mean, it's pretty extreme. So obviously the court decided that in that case, the tribunal's decision was inexplicable, and not only that, it went beyond being inexplicable. The fact that an award fails to address one of the parties' arguments expressly does not, without more, mean that the tribunal failed to apply its mind to that argument. There may be a valid alternative explanation. So on its face, the court is actually very generous in the way it will interpret an award. But nevertheless, in that case, it did order setting aside. It was asked to consider whether to remit the award back to the tribunal. And it expressly said it would not do that because it felt the tribunal would not be able or willing to revisit the matter in a fair manner. And so for that reason, it set aside the award. So it can be done in exceptional cases. And it does, as I say, highlight the importance of lists of issues. And you do often have cases where it's hard to get the parties to agree on lists of issues. But my learning is persevere. You know, you've got to get there one way or the other. And as Jacqueline knows, we had some experience where we, after some initial bumps in the road, we did manage to encourage the parties to agree a list of issues. And I was very thankful that we could. And when you come on to drafting the award, it just makes life so much smoother if you have that list of issues as the outline, and you don't have to think too hard about whether you're somehow inventing things yourself. Which is clearly what the tribunal in that BZW case had done. So that's what I'll say. Thank you.
Thank you. Katrina, any top-up comments on this, either from usage of list of issues or right to a fair hearing, as explained by the Hong Kong courts?
I think one of the interesting issues that came up was in what circumstances can the court hear new evidence on a review from an arbitration. Now, this is not so much, I think, the plaintiff or the applicant being deprived of an opportunity to be heard in the arbitration, but where in circumstances where you are reviewing an arbitral award on jurisdiction, because it is a hearing de novo, then the court can have the jurisdiction of the entitlement to allow parties to adduce new evidence and to call witnesses and that sort of stuff, and raise new arguments as well, which to me it's quite interesting because, of course, if the tribunal rules that it has no jurisdiction, then that's final. If the tribunal rules that there is jurisdiction, then you can review it. Now, I think the interesting question would arise if the court on review upholds the tribunal's ruling that there is no jurisdiction, but then having heard new evidence, then makes new factual findings that may impact on the liability issue. And then, of course, logically, the parties would then be stopped from relitigating those factual issues. And so I don't know if Ian or anyone have any thoughts on how that may impact on the subsequent arbitration proceedings. But one would think that perhaps the matter would be better dealt with by remitting back to the arbitrator, so that the arbitrator can, in light of the new factual findings from the new evidence adduced before the court, then make further findings in the arbitration. So from that perspective, then from the perspective of practitioners, I know arbitrators hate bifurcated hearings. And normally, a lot of times they rule that the issues on jurisdiction should be heard at the same time. But there may be, I think from that perspective, I think as Robert said this morning, there may be some advantage to having a bifurcated hearing. But I mean, not on liability and quantum, but also on jurisdiction and liability.
Thank you. Jose, any additional comments or war stories to share?
I think just going back to the observation by Madam Justice Mimi Chan on the threat of lawyers bringing bad cases, and also on what is a fair hearing and impartiality. And it's important to bear, why are there so many cases? Purely about, you know, did the tribunal deal with that submission? Was the timetable fair? Did the co-arbitrator attend a cocktail party 6 years ago where one of the counsel was there? It's because the way, unlike judgments where you can appeal because the facts are wrong or the law is wrong, because you can't, you're stuck with it. So as bad as the law may be, as bad as the facts may have been found, you're stuck with it. So the only thing you're left with is this so-called procedural integrity, which entails impartiality and fair hearing. So parties will then basically drill to the nth degree trying to find something. And that sort of exercise, of course, takes a lot of time. And if you're the parties' lawyers and you charge on the customary basis, you're perhaps less bothered. But if you're the court, it means that you have to spend 10 days, 15 days in trying to understand the case in the award in a way which simply the diary won't allow it. So you can understand from the court's perspective why the task you're supposed to do in a one-day hearing, find whether or not an argument was given sufficient weight in the hearing, which took 20 days, is not particularly practicable. But just by way of example, this idea that you don't get a fair hearing because, for example, the timetable's too compressed. There's a recent case in Hong Kong that's AA and B, another decision of Deputy High Court Judge Reyes. There he held that because the parties at the time made no complaint, did not seek an adjournment, that meant that they were precluded at a later stage from trying to argue it. And you can see why, because what the courts don't want is for parties to see what the result is. If they win, they're very happy. If they lose, they then say, well, actually, 12 months ago, we didn't have enough time, although we didn't apply for an adjournment. So that's an example of the court being quite robust in terms of upholding the case management powers of the tribunal.
Thank you. Henry, you have described to us just now that arbitrations in the mainland proceed in a very different way. From the perspective of the common law's concept of right to a fair hearing, does Chinese parties and mainland practitioners feel very strongly against certain sentiments being expressed because it doesn't really fit well with how the procedure is being run in, for example, CITEC arbitrations?
I think the fair hearing concept, of course, is important, and actually that should be respected in whatever jurisdiction. However, you need to, when it comes to different jurisdictions, perhaps you need to think about the different actual situations where these rules, this important principle can be fulfilled. Let me give an example. In a lot of cases now, the mainland Chinese award is trying to be enforced elsewhere. In addition to the enforcement procedure in mainland China, usually the winning party will try to establish the procedure in Hong Kong at the same time. And again, as I just said, the losing party in China, in mainland China, has the tradition that they will always try to challenge the validity of that award. So there will be a judicial review process be established in parallel, one in mainland China, the other in Hong Kong. And usually, in order to save cost, they will wait till the mainland China part finishes, because that takes less time and with less cost. And we have seen quite a few cases that the mainland Chinese intermediate court has already turned down the proceeding by the losing party to set aside the arbitral award, which means that arbitral award is recognized in mainland China by the court system to be a valid award. While in Hong Kong, the losing party won that judicial review process with certain reasons like public policy, like the right to be heard, the fair hearing, things like that. And this will put the winning party of that case in a terrible situation, because the winning party will not have a single chance to revisit this case, to re-establish another arbitration case in the original arbitral institution, because that has been recognized as a valid award in mainland China, while any of its rights under mainland China law is not recognized by the Hong Kong court. So to that specific winning party, it will view this as an unfair treatment to itself. Sometimes it's because of the penalty to that sleepy arbitrator.
Indeed, we have seen a lot of cases, at least in Hong Kong, where there are parallel post-award proceedings before the Hong Kong as an enforcement court, but also the court of the seat of the arbitration. And I know that in the mainland, Hong Kong and Singapore, the courts as the seat of the arbitration do have the power to remit a certain matter back to the tribunal for reconsideration. And it's very interesting that in China, it's being translated into re-arbitration, 重新仲裁, which might not be the same idea of what is meant by power to remit in the common law countries. I'd like to pose the last questions to our panelists is, how do the courts in these jurisdictions interpret such power? And have you experienced in real cases any exercise of this power by the courts in your case? Or have you experienced facing an order inviting the tribunal to reconsider certain issues? What's your reaction? We'll start with Henry. What's your observations on this?
In mainland China, one of the parameters that we look at, we judge whether an arbitral institution is good or not, is the setting aside rate of their cases. So whenever there's a possibility of a court turning down one of the awards of that specific arbitral institution, it's an implied principle that usually the institution will talk to that court to see if the reasonings of the court to set aside that award is sufficient. That happens. Well, but that doesn't appear in any of the procedure sort of laws or rules, but that happens. Having said that, I would say this also leads us to another interesting discussion on whether the review process within the arbitral institution of the draft award is important or not. Well, in China, I would say yes, because sometimes you do see issues, not because of, well, there are issues of all different kinds. It can be the issues of the arbitrators themselves. It can be the inexperience that they do in drafting awards. It can be they are just unfortunately being influenced by one of the parties. It happens, or it happens with a reason. So this gives the arbitral institution, the first tier ones, there aren't many among the 280 ones, the right to justify, to at least strike the balance between a good arbitral award as well as the final decision and attitude of the arbitral tribunal, and the last result of that, which is the judicial review and turn down. So I would say in mainland China, you find that everything may happen out of the box, not only strictly according to the rules and practice.
Thank you. Robert, any thoughts on this?
Thank you. A couple of thoughts. So one thing I see a lot more of in Singapore is use of expedited procedure. So I will often get cases where the parties have agreed on SIAC's expedited procedure, which means you have to issue the award within 6 months of being appointed as arbitrator. So it's pretty fast time frame. And I mean, what often happens in practice, as well as the parties will then slow things down themselves, and it often ends up taking more than 6 months. You can go back to the registrar and you obtain the registrar's permission to have a time extension. But when the expedited procedure is used, you as arbitrator only need to provide brief reasons for decision. And I think once the parties have accepted that, it becomes harder for them to then apply for setting aside. So that is one thought. The other thing I would say is, as we're talking about remission, I'll just come back briefly to this BZW case I alluded to. And the specific reason why the Court of Appeal in that case decided that it could not remit the award was because the tribunal had initially made an error as to a particular witness, which side that witness had appeared for. So, I mean, yeah, this does sound slightly humorous, I have to say. And when presented with this fact that it made the error, there but for the grace of God go I, although I do think that is a fairly serious error to have made. When presented with that piece of information, they corrected the award, but what they didn't take into account was that the claim that they were allowing based on estoppel could make no sense, because there was no representation by the side that needed to have made the representation for there to be an estoppel. And so that was the reason why the court decided not to remit. It was like, well, you know, if they can't see that and the problem there, then what's the point of remitting? Thank you.
Katrina, any further response from Hong Kong court's perspective? Is it useful to eliminate blemishes, so to speak?
I think so, and I think we have, from recent cases, we have seen the court exercising the power to remit more. I think in the case of GNN, what happened there was, I think after the arbitral award was given, the law changed. So in relation to that particular case, it was, yes, it was the test of illegality. So many of you will know the traditional test in Hong Kong that was applied was Tinsley and Milligan, and then subsequently in the Court of Appeal in Monat, they decided to follow Patel and Mirza and the range of factor test. So what the court did in that case was saying, well, instead of me being compelled to set aside the award, what I'm going to do is to remit it back to the arbitral tribunal so that he can do whatever he can do to eliminate the mistakes, to wipe out the blemishes, and then apply the new law. So I think, you know, that's a very good approach.
Jose, any final remarks?
Just 2 points. First, another example, which is AA and B again. So what happened there was one party said that a particular point hadn't been dealt with. The other party, trying to uphold the award, said it was implicit in the tribunal's reasoning. The court there said, well, obviously three possibilities. One, you say it's dealt with there. The court wasn't quite satisfied. Two, you set aside. That was considered too extreme. So the court in that case remitted so the tribunal could clarify. Then the second point, which arises out of what Ning said earlier, which was you can imagine the terrible situation of a party who has won, resisted the set-aside, for example, in the seat of arbitration, say in mainland China, but yet you fail at the leave to enforce because you're stuck. You can't set aside your own award. If the assets are all offshore, you end up with an award you can't set aside yourself. You can't turn into money because you can't enforce here. So the obvious point, therefore, is that when you appoint an arbitrator, if one of the main purposes is to try to enforce on assets which are outside of that particular jurisdiction, having arbitrators who at least have experience of what the standards would be applied and used in the jurisdictions where the assets are would be an obvious consideration.
Thank you very much. It is an honor for us to have all four panelists today. Speaking for myself, I have the privilege of working under the wings of some of you up here before you, and I'm in charge today. I'm the one firing questions to you, so that's fun. And I think this panel is a very good demonstration of mutual sharing of litigation cultures across different jurisdictions, and I think that's why DVC, we have our conference today. We believe that we do have the ability to shape future international arbitrations. Thank you very much, everyone.
Thank you very much. Thank you once again to our guest speakers, Mr. Henry Wang and Mr. Robert Pei. A round of applause. Thank you.